Welcome to Perspective with Derwin L. Webb. I am Derwin L. Webb. We are coming from the Fraser Museum today, and we have an opportunity to discuss something that has just come to the United States and to American jurisprudence. Today, in a landmark decision, 6-3, the Supreme Court struck down affirmative action for colleges and universities as far as admissions is concerned. And I have an opportunity to bring on a person that can discuss this a little bit further. Cedric Powell is a University of Louisville law school professor. He's well known for constitutional law, his race relation pieces, and also being my fraternity brother. Brother Powell, welcome to our show. Thank you for coming today.
Thank you so much for having me, brother. Appreciate it.
Man, I could start off by talking so much about your background, being from Oberlin College, working in New York, and coming to the University of Louisville, being my professor. So for all those listening, if they like anything that I do, it's because of you. If they don't like anything I do, it's probably because of you. You've been my mentor for a while now. I appreciate all the things that you have taught me and all the other students that came after me since you've come to the University of Louisville. But let's just go into it. Today was a big decision. 6-3, affirmative action is no longer the law of the land for colleges and universities. How did we get here?
It was a long journey. It started in 1978 with the Baki decision. So we're looking at 45 years of precedent that the court has disrupted. Now, Baki was an interesting case because it was splintered. It was a plurality opinion, and it looked at Title VI, which deals with private universities, and the 14th Amendment, which deals with public universities. And on both instances, this is what the court ruled in. The present case is that the 14th Amendment was violated, and by implication, the Title VI as well as private universities. But Baki was interesting because it really gave us the language that we're dealing with now when we look at this decision. As I said before, Justice Powell comes out and says that the set-aside program, there were 16 seats set aside for medical school applicants, only reserved for people of color. And he concluded that that was an impermissible quota, unconstitutional under the 14th Amendment and Title VI, because you are cordoning off the seats and not letting anyone else participate is based upon their race. And the court said that is unconstitutional quota. But by the same token, he also says that race can be used, now this is only his opinion, race can be used to promote diversity. Diversity is a compelling interest in university admissions. But he rejected a lot of rationales to get to that point. He rejected the notion that doctors of color would go back to serve underserved communities, that we need to eradicate intentional discrimination. He really couldn't find any and just said that this is societal discrimination and beyond the reach of the court. And so he settles on diversity as a compelling interest because it has great educational value. But again, as was said in this opinion, the North Carolina Harvard decision, the court concluded that that was a splintered decision and really has precedential value, but it's something that we should move away from. So finally, 25 years later, in 2003, we had the Grutter decision, which is what we're dealing with now. Right. And the court was very deferential, 5-4 decision, and says that universities occupy a special niche in our constitutional tradition. The First Amendment means something. We can have a robust exchange of ideas in a classroom, and we want to give educational autonomy to school administrators to determine the composition of their classes. So diversity is a compelling interest. For the first time, a majority of the justices say that. And the program has to be narrowly tailored with holistic review of individual candidates, and race is a plus factor. This whole notion of critical mass in the classroom means that we don't want tokens. We don't want one or two people in a predominantly white class speaking for the race. We want a critical mass. There's no number put to that, but we want enough students to make this educational enterprise beneficial for all. So that is not a quota. It promotes cross-racial understanding. And then she says something that becomes really the focus of the opinion today, where she says, hopefully in 25 years, we won't have the need for race-conscious remedies. And that number is purely arbitrary. I think that she just pulled it out of a hat because it's 25 years after Baki, so I guess her reasoning was 25 years after Grutter, we won't even need race-conscious remedies. And we're coming up on that deadline, but we're 5 years from it. It would be 2028 under that calculation. And then a companion case held that the automatic distribution of 20 points based upon race in the undergrad system was unconstitutional. So you can't have numerical quotas connected to race. That is a racial result, and that is unconstitutional. And then finally, before we get here, we have two cases, Fisher 1 and Fisher 2, where Abigail Fisher, a white complainant, brought an action saying reverse discrimination. You have this system, I have the credentials, and you kept me out because I'm white. And the court looked at that and said, we're going to be very forceful in how you apply strict scrutiny, which is the highest level of scrutiny based upon race, because race is inherently suspect. And we're not going to be very deferential. We want you to narrowly tailor it. In other words, we want a connection between your justification for the use of race, the means that you choose, and then the goals that you achieve. And if you can consider race-neutral alternatives, you should do so. And then if you can't you do it through race-neutral alternatives, you can look at race. Then on remand, and this is in 2013, the Fifth Circuit upheld the Texas program using race. And the Fifth Circuit is a very conservative circuit, but they upheld it anyway. And so then it makes its way back up to the U.S. Supreme Court in 2016. This is Fisher 2. And the Supreme Court, by a 4-3 majority, upheld this Texas program, which set aside 10% of the seats to the highest achieving high school students across school districts. And Justice Kennedy, writing for the court at that time, said that race could be a factor of a factor of a factor, meaning that race can be one of many factors in holistic review. So again, just 7 years ago, the U.S. Supreme Court affirmed this notion that diversity is a compelling interest. You could use race as one of many factors, a plus factor in holistic review, and race may not be considered unless the process can meet strict scrutiny. So some deference is accorded to school administrators in terms of looking at diversity, but we're not going to give you any slack or deferential review when you talk about narrow tailoring. We want a close fit between justifications and the use of race. And then Justice Kennedy finally says that there should be periodic review of the admissions program. Now, since 2016, there's been litigation in the lower courts about University of North Carolina, oldest public university, and Harvard, probably one of the oldest private universities, and then the constitutionality of those programs. And the interesting claim is that if you take race into consideration, it's impacting who gets into the class, particularly Asian Americans and whites. So what's really interesting here is for the first time you have Asian Americans advancing a reverse discrimination suit in order to get rid of race-conscious remedies. And the court bought this argument, and it's an example of the court's post-racial constitutionalism. Chief Justice Roberts, many years ago, in a case that happened here in Louisville, parents involved in community schools said that the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. And so that is really the first post-racial pronouncement of the Roberts Court. And I talk about that, not hawking my book, but I talk about that in my book, Post-Racial Constitutionalism and the Roberts Court, Rhetorical Neutrality and the Perpetuation of Inequality. So that's what brings us up to this case. And so I've been talking, so I'll just sort of step back and let you ask specific questions about the case, because that's how we got here.
Okay, instead of asking specific questions about the case
Okay.
right now, for those who have been living under a rock,
Okay.
exactly what is affirmative action?
Affirmative action is, and so that's an excellent question. Affirmative action is looking at the entire person. Race can be one of many factors, and you're not slacking off in terms of merit or achievement or what this person can bring to the classroom. You're saying we're going to look at the entire person. And so Baki really says you can look at a white tuba player from Idaho who likes Charlie Mingus and wants to work in a community center. That's the same thing as an African American who might have an interest in Bach and is a conservative Republican. Those two things don't totally define those persons, but those are a number of the components that we will look at in assessing this individual. So affirmative action has never meant lowering standards just to let people in because of a race-based result. It has always meant looking at race as one of many factors, acknowledging that structural inequality exists, acknowledging that exclusion has impacted people of color in a particular way because of our history of racial oppression, and trying to open up education so that everyone benefits from the discussion.
Okay, so why is it important, though?
Why is it important?
Yeah, why do you feel it's important?
It's very important, and I think this is what we are fighting about now with Grutter decision. Everyone breathed a sigh of relief when we talked about the Grutter decision because we had Justice O'Connor, not a liberal judge by any means, but a moderate judge, who really talked about the meaning and impact of diversity. And she makes a point that the pathway to leadership is only legitimate when it is open to everyone. Everyone gets a chance. And everyone gets a great education if you have more than one perspective in the classroom. Diverse perspectives lead to cross-racial understanding, she would say. And so what we're trying to do is improve future leaders, bring about diversity in education, create new knowledge and broaden that, encourage a robust exchange of ideas, look at an engaged citizenry who understands that there are different people that make up our democracy. So it's vitally important, not just in the educational system, but in the preservation of our democracy.
Okay, I'm going to ask you a question that doesn't have to do necessarily with the law as much as it does with your opinion. Are you surprised that this happened today?
Absolutely not surprised. I've been talking about this leading up to the case, and there's a chapter in my book on Fisher 2 where I sort of, the decision hadn't been decided yet, of course, but there's a footnote that says that this is the possible result, that you have a model minority, Asian Americans, advancing this reverse discrimination claim and saying that race-conscious measures are being used to displace people when they have the credentials to get in. One thing that was really surprising to me about this case, and it doesn't, totally explicitly say we're overruling Grutter and Gratz and Fisher, but it does totally dismantle this concept of diversity. And what I mean by that is Harvard and the University of North Carolina based their programs on Baki and further extension on Grutter, and they really talked about what we've been talking about, developing future leaders, adapting to a pluralistic society, making sure that there's diversity in education, creating new knowledge, making sure that there's a robust exchange of ideas. All of those concepts come from Baki and Grutter, and Chief Justice Roberts, in his opinion, goes through each and every one of those and says, well, that's nice, that's laudable, and there may even be some benefits to that, but we can't measure that constitutionally. How can we be sure that there's a logical stopping point to the use of race? So these concepts are too murky and soft to the court, and Chief Justice Roberts makes a point of saying, yeah, you talk about all of this, but you really haven't told us what it is and how it can be measured, and more importantly, when will it stop? And all throughout the opinion, over and over again, he says that the purpose of the Equal Protection Clause is eliminating racial discrimination and eliminating all of it. And that means doing away with all governmentally imposed discrimination based upon race, which is really a post-racial statement. We don't want race in government decision-making on any level.
Okay, now I know that you have read through all of the opinion today.
Most of it. It's 200 pages, though, but most of it.
Okay, talk about the dissent then.
Okay.
Talk especially the most recent Supreme Court justice.
Okay, yeah, let me sort of set that up. So one of the things that Chief Justice Roberts does, I want to do this to set up the dissent. Okay. One of the things that's really interesting that Chief Justice Roberts does is he goes through all of the 14th Amendment and talks about these groups of cases. We could do separate podcasts on each of these cases. But if you take them all together, they stand for the proposition that there are only two instances where you have compelling interests that permit the use of race. One, he says, is if we can find clearly identifiable instances of discrimination. I mean, that's virtually impossible. You have to find the state actually did this, intended to do this, and we have proof of it. That's an old case, Washington versus Davis in 1976. So that's one ground. And then another ground that seemed kind of new to me was avoiding imminent and serious risks to human safety in prisons, such as a race riot, he says. Now, that's really interesting to me. He says the only time that you can use race as a compelling interest is if you can point to something that the state did intentionally or to avoid imminent risk and serious human safety based upon race. Now, that's kind of new to me because previously it was understood that diversity was the other ground for using race, and diversity was a compelling interest. But he sort of expands this concept and says university programs must comply with strict scrutiny. They may never use race as a stereotype or negative, and at some point they must end. That's a quote from the decision. So what he's really talking about is eliminating race. And when will it end? So he says 20 years later, no end is in sight. Racial discrimination is invidious in all contexts, which is a great departure from the education cases, because Justice O'Connor would always say context matters. Strict scrutiny is strict in theory but fatal in fact, but it's a little bit different in the context of education. We're willing to give a little bit of leeway when we talk about race and education. But Chief Justice Roberts does away with that, and he says these programs, University of North Carolina and Harvard, are unconstitutional. They lack any focused, measurable objective that warrant the use of race. So what is diversity is the question. It unavoidably employs race in a stereotypical way by assuming that just because people are people of color, they'll have a certain viewpoint or they'll act a certain way, and that really is negative as well. And there's no meaningful stopping point. And so it has to end at some point, and Chief Justice Roberts says it has to end now because neither North Carolina or Harvard have given a compelling reason for using race in this way, and we want to get rid of the use of race. So that's one interpretation of the 14th Amendment. Very formalistic, very neutral, very devoid of reality because it doesn't take into account systemic racism and structural inequality. So that brings us to the dissent. Chief Justice Ketanji Brown Jackson authored a excellent dissent. And it's really devastating what she does because she's making a point counter to Justice Thomas, who always talks about originalism and what the Constitution really means. She makes the point that the court is very careless in its analysis, very cavalier. And I'll just quote from her dissent. I think this is circulating all over the internet. This is from her dissent, and it's very pointed. Quote, "With let them eat cake obliviousness today, the majority pulls the ripcord and announces colorblindness for all by legal fiat. But deeming race irrelevant in law does not make it so in life. And having so detached itself from this country's actual past and present experiences, the court has now been lured into interfering with the crucial work that University of North Carolina and other institutions of higher learning are doing to solve America's real-world problems. No one benefits from ignorance. Although formal race-linked legal barriers are gone, race still matters to the lived experience of all Americans in innumerable ways, and today's ruling makes things worse, not better," end quote. So that's very devastating. She's pointing directly at Justice Thomas and Chief Justice Roberts and saying, you're so dedicated to originalism. Well, the 14th Amendment, as one of the Reconstruction amendments, was designed specifically to eradicate racial caste and disrupt and dismantle structural inequality. And this decision takes us backward to a post-racial mystery tour that really has no basis in reality. So I thought that was very poignant. I know that Justice Thomas tries to respond to that by talking about originalism and neutrality, but he starts from the vantage point that Brown versus Board of Education means something different than what we think it means. Brown versus Board of Education is a colorblind decision. It's not about eradicating separate but equal, really, but providing equal educational opportunity for everyone without regard to race. So he takes out the whole context and tenor and reasoning and rationale of Brown, rooted in the anti-subordination principle, and really shifts that to one of neutrality, not looking at real-world consequences and just saying that race has to be excised out of every type of decision that we make.
Almost saying that this is the same thing.
Yeah. Almost the same thing, exactly. So that's a good point. So he always says that there's no difference. Because you're using race is so explosive and noxious, we need to stay away from it. So it doesn't matter if you're telling me that you're doing something good with race, like looking at race as one of many characteristics and letting people in. You're still using race, and that's bad. And that makes people resentful. That makes people who get the benefit feel stigmatized. That makes their achievements be devalued. And Justice Thomas has made that argument about his own achievements when we talk about his time at Yale Law School. Yeah.
Let me ask you this. In law, we talk about unintended consequences.
Indeed.
So obviously, this is a decision that has to do specifically with college education, college institutions of higher education. What does this actually do? What box does this open now?
It opens many boxes, but I want to be careful. One thing I want to do is to sort of say that this, first of all, is a narrow decision. It deals with education, higher education, doesn't deal with K to 12, just higher education, colleges and universities. That's true. But you're absolutely right about the litigation and strategic posture of this case, because there's a whole line of cases that are cited in Chief Justice Roberts' decision that the court uses to say that decision-making should be colorblind. And I would take it even further. I make a distinction between colorblind and post-racial. To me, colorblind means you can be neutral in decision-making, but look at race as one of many factors. So you're acknowledging race, but using it in a neutral way. That was what the Rehnquist court was doing under Justice O'Connor. This Roberts court has completely shifted and says that race should not be a part of any decision-making. And so that's really what happens in this decision. Now, the unintended consequences, I think, could go into minority contracting. It could go into the corporate boardroom. But of course, we're not there yet, but I'm just anticipating that there could be litigation on those issues. Another unintended consequence here is because the court really doesn't give any guidance. What's going to happen is there's going to be litigations about whether or not race is being used. In other words, whether or not these neutral things that you're saying are being used, whether or not those are proxies for race. Because one interesting thing about the decision, and people are trying to find a silver lining in the decision. One thing that Chief Justice Roberts says is, of course, someone can talk about their race in a personal essay. A discussion of how race affects a person's life is fine, but he also says college administrators and colleges don't use personal essays to get around this decision and circumvent the reasoning of this decision. In other words, a discussion of race that affects life has to be connected to some neutral factor. And so a quote from the decision says, in other words, the statement must be treated based on his or her experiences as an individual, not on the basis of race. So you can write about your racial experience, but that can't really predominate. On some level, you have to neutralize that. And I think that's going to impact, first of all, how students write their essays, and even more drastically, whether or not they will apply to a particular college because of where it's located, Florida seems to come to mind, Michigan, California too, because those are two states where affirmative action has been banned. So this is going to have a lot of unintended consequences, I think, that we haven't anticipated yet.
Well, I'm glad you said something about California, because I know that California banned this back, was it 2020?
Yeah, well, that's the second time around.
Right.
They tried to re-implement affirmative action by overturning the proposition that had passed before, and they lost on that. And liberals were really surprised by that. It really raised some eyebrows, because they thought that there was support, and there generally is support for affirmative action, like 53% to 42%, but it's all the way that those voter initiatives are worded. So if you talk about fairness and then you put race in it, usually the voter initiative is going to go down. And so California has been an area since the early to mid 90s that has prohibited the use of race, and then they tried to get it back, and that was rejected by the voters as well. Yeah.
Okay, I know that you've been on admissions at the University of Louisville School of Law. I know that. What can you look at now?
Well,
race is out.
Okay.
What can you look at to look at an application to determine and to make sure that diversity is still part of your school,
right?
A part of the things that you think that you feel is important for a diverse student population.
Right.
What can you actually look at now?
So that's interesting. So we're in a position now where we have to look at race-neutral alternatives, while at the same time not discouraging people from being their true self. So you can't tell someone not to write about race. And I think even Chief Justice Roberts concedes that. But the real battle will be, how will they use race in their essay? How will they use it in terms of presenting their full self? So I think what I would look at if I was on the admissions committee is, the race-neutral things, overcoming adversity, first-generation college, zip code, demographics, unique experiences, unique interests, anything that would add to this notion of the marketplace of ideas in the classroom without making race the predominant factor. So in many ways, we're sort of where we were before, but you have an explicit pronouncement from the court saying that race can't be in this, but at the same time, the court says people can talk about their race in their personal essay, but not in a way as to circumvent this decision, which is murky and ambiguous and contradictory. So I think that universities and colleges are going to come up with their own programs in order to make sure that diversity is preserved. Another thing that I see that's happening is that the Department of Education just announced that in about 45 days, they're going to be proffering a guidance to all colleges and universities about what the decision means, what it doesn't mean. There's going to be a national summit on educational opportunity. And I think it was also announced that by September, the Department of Education will be putting out a memo on best practices, what can be done. And so all of these things are helpful. But I think back to the states that have banned affirmative action, the results there have been limited, and most of those states, the percentage of people of color admitted has gone down, particularly in California and Michigan. Those numbers have gone down. Some studies say that they've returned back to a little bit where they were, but most have it decreasing. And the numbers that we're talking about aren't very high anyway, and so that's deeply disturbing. Yeah.
How many steps backwards did we take today?
Many steps backwards. This is part of what the Roberts Courts does, and that's what everyone is talking about, legitimacy, because how can we believe a court that makes up constitutional doctrine in order to reach a result that's almost predetermined? Whenever there's a race-conscious case or a case with racial underpinnings, you can pretty much tell how it's going to go. Now, everyone was happy about the voting rights case because it didn't overturn Section 2 and all of that, but that's fine. But and not to be a pessimist, but I want to point out that in 2013, the court dismantled the Voting Rights Act so much that ruling, this recent ruling, is nothing more than preserving the status quo. And so every time we take 2 steps forward, we take 4 steps backward with this court, and the court rationalizes subordination. So it's really looking at the Constitution differently, in a way that sort of weaponizes oppression. So I think we've taken many steps back. And the most devastating impact is that you're once again, just as in the abortion decision and the gun rights decision, you're overruling well-settled precedent that everyone had relied upon. This is 45 years of precedent, if you look at it. And Chief Justice Roberts will say, no, not 45 years of precedent, because Baki was a splintered plurality opinion, and one man was talking about diversities. Well, if you look at Grutter, 2003, that was the first time that the court said diversity was a compelling interest. That was 20 years ago. And Justice O'Connor was saying, we're going to take our time and look at this. And now the court has overturned all of that jurisprudence. So we've taken a devastating step backwards.
Well, I heard Mike Pence say today that it's about time.
Mm-hmm.
And he even used Dr. King talking about people need to be judged by the content of their character instead of the color of their skin anyway.
Right.
What do you say to the person that agrees with those sentiments because in their minds, we're all equal now?
Well, we're all equal theoretically, but the only way that proposition in theory works is if you totally ignore the present-day effects of past discrimination, you totally ignore structural inequality and systemic racism, and you totally ignore the benefits of being white in this society. I mean, white supremacy certainly matters, and so all of the things that we have in place that reify white supremacy, that advances it, that makes it more difficult for people to enter these educational institutions and other places, we have to take that seriously. And it's a common enterprise. All of us have to be engaged in advancing substantive equality. So I think if you look at it as, well, it's just fair, I did everything I was supposed to do, that's fine if you look at it individually, but you're not looking at the broader implications of the way that this society is structured. And you have to do that if you want to make a realistic assessment. That's what Justice Ketanji Brown Jackson is talking about in her dissent.
Last question.
Sure.
Are you hopeful for the future?
Well, I have to be. And so you cannot be pessimistic, and you have to be hopeful in order to survive. And I think one of the great things that Derek Bell did in all of his scholarship, and he took a lot of heat for this, was he brought out the permanence of racism, but he also underscored this notion that fighting and struggling is a noble enterprise, and we have to do it as a people with a history of oppression. In other words, the only way that we can dismantle this structural inequality is to engage it directly. And this is just another opportunity to do so. One thing that struck me today is I saw the press conference of the complainants who won this decision, and of course they were gloating, but one thing that they did that was really off-putting to me was they issued a warning that they would be closely monitoring colleges and universities and were prepared to litigate any issues. And so I saw that as a bold attempt to cower university and college presidents into just accepting the status quo. But we have to do more than that. I think universities and colleges have to be robust. They can't be afraid of being sued, and they should embrace and reaffirm this notion of diversity because it is truly meaningful.
Brother Powell, we have come to the end of our time.
Oh, wow, it went so fast.
It went very fast, but I appreciate you being here. I knew that once this happened today, I had to figure out, okay, how do we get the people to understand this? And
that's right.
I could not think of a better person to break this down than you.
Well, that's nice
I appreciate everything that you've done, done for me especially, but for breaking this down and helping people to understand the complexity and also the long-reaching effects of what this decision could make is very beneficial for us. So I appreciate you coming on today,
well, thank
especially
you so much.
at the last minute.
Oh, not at all. Thank you. This has been a evolving day with lots of fast-paced news, so I really enjoyed the opportunity to come down and be with you. It's a great honor. Thank you.
Thank you for coming.
Yeah.
As we close on our show, what we always say is, it doesn't matter what you say, doesn't matter what I think. At the end of the day, it's always a matter of perspective.
That's right.
Thank you very much, sir.
Thank you.